Our position from the beginning has been that she kept it from my client.
What did she keep?
The fact that it was his child. We have evidence that she denied it to him and is now seeking retroactive child support, in which case I believe that becomes extremely pertinent and relevant. By lying to him about him not being the father, he hasn't been able to establish that relationship. Your Honor, this is a case brought up for the Master's Court. It was filed as an original SAPSER against my client to establish paternity, child support, and custody. Up to probably late last week, we had an agreement. The agreement was termination with an intent to adopt by stepdad. Up until, like I said, about Friday, I was notified that Ms. Cortez had a change of heart and thus would be wanting to proceed as per her original SAPSER petition filed by Mr. Gonzalez at the Attorney General's
Buckle
office.
up, guys. Today we're diving into a courtroom moment that starts with a serious accusation. Right out of the gate, the father's attorney claims the mother hid the truth, that he was the child's father all along. That single statement sets the tone for everything that follows. Now the stakes are clear. Not just child support, but lost time, lost connection, and a question of honesty that could shape the entire case.
For that reason, I filed the motion for continuance, Your Honor, advising the court that if that's going to be the case, then we need to come back and change our posture altogether. So I was requesting a PTGO so that we may do some discovery. Our position from the beginning has been that she kept it from my client.
What did she keep?
The fact that it was his child. We have evidence that she denied it to him and is now seeking retroactive child support, in which case I believe that becomes extremely pertinent and relevant. We need some discovery as to that, as well as some other issues. We're also going to be seeking attorney fees, and we had actually filed a counterclaim seeking custody. Because of the fraud, we're alleging that he's been kept from developing a relationship.
I'm sorry, the last thing you said was that you're going to do what now?
I wanted a PTGO. We filed a counterclaim on the original SAPSER, asking for primary conservatorship.
So you have you have two competing requests. You have your initial request is to terminate your client's rights.
We after filing a counterclaim for primary conservatorship, Your Honor, our negotiations, because of the fact that my client has no relationship with the child, went toward termination. That was the agreement up until, like I said, maybe Friday of last week. And so
all right, guys, this is where things start to unravel. What was once a settled agreement suddenly falls apart, and both sides are forced back into conflict. The father's side shifts from agreeing to termination to now seeking custody, while the court tries to make sense of these competing positions. The tension builds as the judge points out the contradiction. How do you go from giving up rights to fighting for them?
Oh, that's why it came as a surprise to me, because there had already been, we were just pending a notice of intent to adopt.
But your client's life pleadings, and obviously families are changing, they're evolving, they're organic, they're not static. So things change as time goes on. But for purposes of this case, the life pleadings are termination and sole managing conservatorship.
That is correct.
Mr. Garcia? Before I hear from you, and Mr. Martinez, the disagreement, do you believe, and I'm going to ask Mr. Garcia the same question right now, do you believe that the non-agreement at this juncture is on the adoption and termination, or only on the adoption, or everything?
I don't know what happened, but apparently it was just termination is no longer, we're not agreeing to it. And okay. I don't think I can ask for it if you're not agreeing to it.
Well, you could, I guess. Court will have to make a determination based on the evidence and testimony. Mr. Garcia, what say you
On this case, Your Honor, we had been going confirm Mr. Martinez and I, Your Honor, but my client, as of last week, she said that she does not agree with the termination, that she's objecting to it, and that she would like to proceed on the establishment of Mr. Hale as the father of the child.
Your Honor, if I can speak.
Who is
Mm,
I don't know who is trying to speak.
Oh, Melissa, the mother.
You are Mr. Garcia's client. Mr. Garcia, would you like your client to speak?
I don't know what she's going to talk about, Your Honor, but I prefer if she would not.
Well, first, Ms. Cortez, please stop moving and bring the video right in front of your face, please.
I'm sorry, Your Honor, it's because I'm breastfeeding my baby.
Please. I have removed the spotlight. Mr. Garcia, what then do you propose that the court do at this juncture?
My client would like to, from what she tells me, proceed on the on the establishment, Your Honor.
Is paternity not established at this juncture, or is it presumed, or why is a termination filed, but paternity hasn't been established?
There was a DNA test, Your Honor, that was done, and it turned out that he is the father. I think it was
Now things get even more intense. The mother unexpectedly speaks up during the hearing, creating an awkward and unfiltered moment that adds to the chaos. But the real twist hits when the judge questions something fundamental. Paternity hasn't even been legally established. That realization changes everything. Suddenly, the entire case loses its footing, and what seemed like a custody battle turns into a legal reset.
an establishment that was originally filed
Well,
because they weren't presumed.
In the biological world, is there a court order that confirmed that study, that test, and adjudicated him the father?
No,
Your Honor, if I may.
Sure.
Your Honor, the Office of Attorney General filed earlier, I'm not sure if it was yesterday afternoon or earlier today, the paternity test, genetic testing confirming that Mr. Hale is the father of the child.
But to the court's point, so biologically he's the father. The question is there an adjudication that legally determined and ordered that finding?
not at this time, no.
So the court at this juncture can outright deny the termination because there is nothing establishing. I guess it's moot because it's not ripe, right? If paternity hasn't been established, there are no rights and there's nothing to terminate. You would first have to adjudicate, this court would have to adjudicate Mr. Hale the father and then terminate rights. In fact, without an adjudication of parentage, the request for sole managing is moot. Also, it's not ripe either, isn't it?
No, it's not gonna. And again,
So then, if all of your life pleadings are moot and or not ripe, what life pleading is left?
I think the one from the Attorney General, Your Honor, that they were the ones who initiated the case.
What is that pleading or request, Mr. Gonzalez?
Yes, Your Honor, I believe this was a patty action. So we were going to establish paternity based off the genetic testing, and we were going to establish child support and everything. That was the original case that we had. I believe I have notes from the previous hearing. My understanding that we were going to do today, we were going to go over the termination and we were going to appoint an ad litem on this case. That's what I have. A lot of stuff happened between then. So
Yeah. So without any final finding, orders, or ruling, I'm just going to make an observation, not a rendition, but the request to terminate and the request for sole managing may be highly relevant in the future, but at this juncture, it's not ripe and moot. So I tell you what, let's do two things so that we can all be on the same page and get on track. I'm going to give you 2 dates. I'm going to give you a final pretrial hearing and a final hearing on the adjudication of paternity on the same date in 45 days, Ms. Flores.
May 19th at 2 p.m.
And then I'm going to give you a final hearing on the termination if it's ripe at that point, but I'm going to schedule it now in June.
June 18th at 9 a.m.
One more time. So final pretrial hearing regarding all issues on this case and also a final hearing on the paternity May 19th at,
2 p.m.
and then a final hearing on the termination should it be relevant, pertinent, ripe, and Mr. Hale would want to move on June the 18th at 8 a.m.
9 a.m. Your Honor.
I'm sorry, at 9 a.m. Now, Mr. Garcia, Mr. Martinez, the court finds it necessary to appoint an attorney ad litem. I think enough has been said here to cause the court to not know. It'll be very hard to now even believe either party on what's in the best interest based on everything that's happened here today. Competing requests and a person not appearing appropriately by video conference. So, Mr. Garcia, Mr. Martinez, the court is going to appoint an attorney ad litem. Any objection to that, Mr. Garcia?
No, Your Honor.
Mr. Martinez?
No, Your Honor.
All right. Who will be filing orders for the court to sign on that?
I can continue.
All right. The appointment of the unobjected to order on attorney ad litem is due to the court on or before.
April 27th at noon by submission.
All right. Any person that would have a conflict with this case that the court should not appoint as an attorney ad litem, Mr. Garcia?
I don't know of any, Your Honor.
And Mr. Martinez?
No, I don't think there is.
All right. I think the court has done everything necessary to get this case on the right track. Anything else on this case, Mr. Garcia?
No, Your Honor.
Mr. Gonzalez?
No, Your Honor.
Mr. Martinez?
I just want to clarify the dates, Your Honor. The May 19th date is for final adjudication of parentage.
And also for final pretrial hearing.
Oh, for final.
So should you need the court to hear anything other than final, you can still do it then, but just make sure you don't exceed that date.
So my concern is if right now my competing request for primary is not ripe and moot, it won't be ripe and it'll still be moot up until that date. Am I correct?
But you're not set for termination, so.
No, but as far as me requesting primary conservatorship, if adjudication has not occurred, then I'm not ready to even assert that. And
Well, I think you know the results of the biologic test. So what we can do is first adjudicate parentage and then move on. So once the court affirms that and makes that finding, then you make whatever request you want.
okay, I guess what I'm trying to get at is we're not going to get to the merits of primary conservatorship on the 19th of May.
Why not?
Well, because I would need discovery, and the ad litem would have to have had enough time to do what he needs to do or she needs to do. We need a lot of stuff before we have a primary conservatorship hearing, I would suggest.
Or you have a primary conservatorship here.
Because that's a best interest analysis that the court's going to have enough information to weigh. And if I haven't even asserted my claims yet, I haven't done any discovery yet, and we haven't really gone forward on any of it. And I understand that biologically it's been confirmed, but not judicially.
Well, that was the court's point, and that's what unraveled the whole thing and got it on track. But if what you're saying is that you're not going to be able to assert your client's ability to engage in discovery because parentage hasn't been adjudicated, I could give you a third date, but that prejudices your client, and it's going to extend the deadlines even more. And if he so chooses to exercise possession, it's going to push it out further. And that's okay if you want to make that request, but just know that you're putting your client in a position to not make that request at least 30 to 45 days further out. And I think under this scheduling order, he can make that claim on May the 19th, not in June or July.
I think, and I believe that my client would tell the court that he's been prejudiced enough, and
By who or by what?
well, by Ms. Cortez, by lying to him about him not being the father, he hasn't been able to establish that relationship.
And that's why we're here.
Yeah,
Yeah.
and so my concern is actually our concern is not really is it going to prolong
Here's where
our
the judge steps in to regain control and bring order to the situation. New court dates are set, and an attorney is appointed to represent the child's best interests, signaling that trust in both sides is shaky. The father's attorney doubles down, arguing deception cost his client a relationship with his child. The case now shifts from confusion to structured conflict, with bigger decisions still ahead. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
our ability to see the child when there's absolutely no relationship there. I think that it's more important.
Well, let me do this to iron that out, because it is a legitimate concern. I'm trying to short circuit, for lack of a better word. But let me ask you this, Mr. Garcia. If we come back on May the 19th, and I can't hold you to it, but just give me your thoughts. We come back on May the 19th. This court listens to evidence and testimony as to what the court should do to adjudicate or not adjudicate parentage to Mr. Hale. If we then proceeded to possession and access, do you believe you would be lodging an objection at that juncture?
There might be an objection, Your Honor, because since there hasn't been contact with the child, my client would probably want to have at least some kind of gradual schedule or something. So I'm thinking
then that was a good call, Mr. Martinez. All right. Give me a final, well, the only thing I can do, final hearing on parent-child relationship on June the 18th, and then a final hearing on termination in July on
July 9th at 2 p.m.
All right, so now you have 3 dates. Final hearing on paternity, May the 19th. Final hearing on parent-child relationship, visitation, possession, and access on June the 18th. And final hearing on termination, July the 9th. Thoughts, comments, questions, or objections, Mr. Garcia?
none, Your Honor.
Mr. Martinez?
I have a concern, and I'll voice it for the court's consideration. If we adjudicate him on the 19th, and thus my pleadings now become ripe, I have less than 30 days to conduct discovery.
Not if you send it before.
Well, yeah, I don't think I can send it because he'd object to the fact that they're not live.
Except that it would be set for final pretrial on May the 19th. I hear it on the same day that the adjudication takes place, and now he has to respond.
Oh, I got it. Okay. But that'll work.
All right. Mr. Gonzalez, anything for the court to consider?
No, sir, not at this time.
Mr. Hale, do you have any questions for the court?
No, sir.
Ms. Cortez, do you have any questions for the court?
No, Your Honor.
All right, Ms. Cortez, Mr. Hale, keep in contact with your lawyers, keep in contact with the attorney ad litem that the court will appoint. I wish you both very well. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.